we'll start. Okay. So we've got, now we're going to turn for the rest of the afternoon to looking at all of the pieces that need to go into the collective bargaining agreement, or I'm sorry, into the structure for setting this up. So Sophie, you mentioned earlier that you prepared this document. It's got a list of all the things that we need to go through, and then helpfully, I think, what our current State Labor Relation Act says, and then what our State Employees Act says, and then just to add another perspective, what the legislation that Maine had passed but never enacted says. So three different, possibly different takes on each of these points. Maybe some of them are not different. And this is not intended to be definitive too, right? I mean, there are going to be other approaches that don't happen to fall in the way. This sort of gives a starting point for having a conversation. Anyway, Sophie, I'll turn it over to you. I think it might be helpful to bring it up on the screen just so we can sort of see where we are.
That would need to say.
Okay, all right.
Is there an issue also that we should be looking at regarding constitutional amendment? And what's in that?
Curious about that too.
Yeah. So Damien, while we're getting set up here, the question was, should we be looking at the constitutional amendment? I think you mentioned that earlier at one point.
Yeah, so the constitutional amendment issue is an interesting question. So it would memorialize in the Vermont Constitution the right of employees to collectively bargain. And during the past session, the discussion on that amendment focused primarily on whether this would grant collective bargaining rights to state employees or other public sector employees who hadn't been given collective bargaining rights yet. And that there wasn't any discussion that I can recall of whether it would impact the collective bargaining rights of agricultural workers. And I think hadn't focused on private sector workers because most private sector workers are covered under federal law, which preempts even state constitutions. So the reason this becomes of interest is because in New Jersey, they do have a constitutional provision that memorializes the right of workers to collectively bargain. And that was the basis for granting collective bargaining rights in the absence of a statute to their agricultural workers following a court decision. So it's hard for me to predict how our courts would rule on a similar action here in Vermont, but it does certainly raise questions as to whether passing that would potentially, I guess the best way to put it would it open the door to potentially granting through court action the right to collectively bargain, even if you don't pass legislation providing for the right to collectively bargain. And so that's probably something that we're in the second biennium of the constitutional consideration, which means at this point the language can't be amended. So it really becomes a question for this year's consideration as to whether that would be either a potential impact that is welcomed or that is unintended. So that's just, I think, something to keep in mind.
Just to raise a question right now, is that something that would be useful to have as definitive a legal opinion as we can before we go forward with this? If the various counsel that we make contact on this are unanimous that it would go in one direction into, say, the New Jersey fashion or otherwise. I think that's important for us to know, to be able to intelligently decide what we need to do here. Our position may well be that we should not, in the second part of the biennium, in the second biennium for that amendment, support it. That we may oppose it. On the other hand, we may say there's less that we need to do here at this point because of that amendment. And, I think we're kind of operating in the dark. And I think it would be inadequate for us to simply take these things in the Vermont laws right now without taking into account the impact of the constitutional amendment.
Yeah, I think, without having drafted a memorandum on the issue, I think in light of the New Jersey case, it certainly opens the door to that sort of action. It is very hard to say how the Vermont Supreme Court would rule on that. But certainly if you want a legal opinion, we can draft one up either for this study committee or for the consideration of the constitutional amendment in the next session.
Well, one question, as far as you're drafting something up, how definitive would your opinion be?
So, I mean, I think the thing to remember with a lawyer's opinion is it's just that it's an opinion as to how we think the court might rule, or what we think the law is. Ultimately, the court is the only one that, writes a firm opinion. I think what I would do is compare the language in our constitutional amendment to the language in the New Jersey constitutional amendment, and compare that decision, and then go from there, try to identify whether there are differences that are meaningful between the two amendments, and whether those could impact the right of agricultural workers to collectively bargain if they brought an action in court to assert that right. And the language in the amendment is quite broad. So, but I don't remember the exact language of the New Jersey amendment off the top of my head. So I'd want to be able to compare and contrast them. But at any point, I'm just one attorney, and Sophie is just one attorney, and neither of us is justice on the Vermont Supreme Court.
So the New Jersey language just is persons in private employment shall have the right to organize and bargain collectively.
Now, does that limit in any way what that means in terms of interpretations of right to strike, for example, or other kinds of actions that some states allow some employers to do and other states do not allow those employers to do that?
Yeah, so it would be, so what the New Jersey court held was that does apply to agricultural workers, and then we would need to look at what New Jersey's labor relations statute is. They don't have a separate one for agricultural workers, so it would be determined by whatever the New Jersey statute is.
Well, I guess the question is that when New Jersey, in effect, authorized, dealt with the constitutional amendment by saying it applies to agricultural workers, does New Jersey allow all workers to strike, or some workers to strike, or no workers to strike?
Right, that would be something we need to look at. I don't know off the top of my head.
Yeah.
Before we interpret that, we should just go ahead on the basis of this limited examination without taking the constitutional implications into account. I think we're falling way short. I'm not even inclined to do that.
I think, Damien, do I remember that you had pulled together in an earlier meeting a chart that shows for each of the 14 states, so New Jersey being one of them, that the answer to that question? The right to strike, for example?
Yeah, so New Jersey was one of them. I did pull together that chart. Let me just see if I can find that chart here. Just give me a second.
ask a question while we.
Yeah.
This being for Sophie, and the constitutional amendment just talks about employees having the right to organize to discuss pay, working conditions. That doesn't mention striking. But my assumption is that despite that blanket language, not not all employees are covered, and including part-time employees, or so there would be exemptions expected that have not been clarified yet. Is that a fair assumption that despite the blanket language, expectation that not every employee would be eligible?
Yeah, it would depend. Typically, you need to have a certain strength of an employment relationship with the employer. So if you're, high school student that comes in one afternoon a week, you're probably not going to qualify as an employee for purposes of a bargaining unit. So typically there are, and I know one of the questions that the committee has to look at is what to do with seasonal migratory temporary workers, but that's certainly a question that, a statute can cover of what, how much that relationship, how strong that relationship has to be. And I've certainly seen in other states, they'll have, you have to have worked X number of hours over the last, 6 months or calendar year, whichever. There are some provisions, so it's not someone that just comes in and is there for 2 weeks and they're counted. So I'm putting up on the screen, this is the chart I think you were referring to that Damien had prepared before. The print's kind of tiny, but it doesn't have anything specific on there, Damien. I don't know if you remember anything, but it doesn't.
Yeah, I think I just found that too. My recollection is because New Jersey, it was based on a court decision. They didn't expressly set out, you shall follow these laws. And so there is no clear law on it. The State Board of Mediation, who oversees other collective bargaining, oversees agricultural collective bargaining too, based on the court order. So it's not clear to me that agricultural workers in New York have a right to strike, or in New Jersey, I'm sorry. The one of the things that we did discuss last year with respect to the constitutional amendment was the question of this idea of, so the constitutional amendment says employees have a right to organize or join a labor organization for the purpose of collectively bargaining with their employer through an exclusive representative of their choosing for the purpose of negotiating wages, hours, and working conditions, and to protect their economic welfare and safety in the workplace. It then goes on to say that the legislature shall pass no law that would infringe on those rights. But that main statement there is that first sentence, that employees have the right to organize and join a labor organization. One of the things we discussed this past session was, well, a lot of our laws say, workforces with 5 or more employees, or workplaces with 5 or more employees in the workplace, that sort of thing. And would the amendment affect that? And the testimony that I gave at the time, and which I would still would still give, is that we have lots of constitutional rights that are limited and cabined by statutes that are enacted later. So, and we don't always agree with those statutes. So we have statutes that, limit our rights to free speech, our Second Amendment rights, that set out guidance about search and seizure of houses or of your personal belongings, etc. And ultimately, the court will listen to challenges to those restrictions on those constitutional rights, and decide if the restriction is valid or not. So in this case, what I had said at the time, and I would think would still hold true, is that while it does say that employees have a right to collectively bargain, if our statutes have set a limitation that collective bargaining rights attach in workplaces with 5 or more employees, that is in the nature of one of these limitations or restrictions on a constitutional right. So Constitution is a broadly written document, and then a lot of the details are enacted through statute. And it would ultimately be up to the courts to determine if the restriction is too significant. But it very well may be that things like that limitation, or the not extending collective bargaining to the smallest workplaces in Vermont would be seen as a reasonable limitation because of the loss of the benefits of collective bargaining in terms of having multiple employees bargain through with a single voice with their employer, rather than having numerous employees bargain individually. So with turning to the agricultural employees issue, again, it's hard for me to say how the court would rule on it. But it does seem broadly enough. It is a very broad statement, and I think it certainly opens the door for a court decision if the legislature chooses not to pass legislation granting those collective bargaining rights. It certainly opens the door to a court case and possibly a decision that would grant those rights in the absence of a statute. So it is something to keep in mind, but I think that question really is more focused on whether to adopt Prop 3 and put that before the voters of the state, and doesn't have as much of an impact on the work of this committee, which is to sort of figure out what an appropriate framework would look like if one were to be enacted, understanding that even the most appropriate framework that this committee comes up with may not be supported by even a majority of the committee. But it's definitely something that you will want to keep in mind and continue to look at as you work on Prop 3 during the coming session.
Well, as I look at this and look at the New Jersey situation, New Jersey adopted a constitutional amendment regarding labor. And if you look at the previous slide that you showed us, there was a footnote 10, which did have a limitation on, I think there had to be 10 days notice before the announcement of a strike.
Mhm.
And I'm assuming that was something that existed prior to this constitutional amendment being passed, although it's unclear.
Oh.
That's
actually
the question
for
that would come to my mind as I
Wisconsin.
look at that, has this been challenged?
Yeah, so that footnote is actually that is for Wisconsin. So their strike provision requires 10 days notice if the strike would tend to cause the destruction or serious deterioration of an agricultural product. And so that's in Wisconsin statute, not New Jersey's.
Oh, I'm sorry. I thought it was footnote 10 related to New Jersey.
No.
Well, is
That
there
would
any,
be number 8, footnote 8, and that just notes that the State Board of Mediation became the oversight body pursuant to a court order.
So,
Colin.
thank you, Mr. Chair. So to Randy's point, I'm just trying to procedurally get this collected in my head. We have in the next biennium or the biennium upcoming, another vote on the constitutional amendment. Assuming it is a positive vote, it then goes to the populace in the state and then is part of our Constitution. So what happens, Damien, if this committee comes up with whatever we come up with in terms of restrictions or amendments to a statute, and then the constitutional amendment gets passed? Do all those things go away and the constitutional amendment trumps everything?
No, so think of it as the same way our statutes that regulate various things that are provided for in the Constitution work now. So you know, we frequently debate issues of gun control in this building. And we all know that the Second Amendment contains a right to bear arms. There may be some disagreement as to how broad that right is. And I would say there is some disagreement as to how broad that right is. And that's reflected a lot in our legislative debates about various gun control legislation that comes into the State House and whether that's an appropriate restriction. And then it's also reflected in the court decisions that either uphold or strike down some of that legislation after it's challenged when it becomes law. So what would happen if the constitutional amendment goes into effect is our collective bargaining statutes would stay on the books. However, if someone thought that they were too restrictive and prevented people from having that right to collectively bargain, they could then challenge that in court. So the easiest example I can think of is the employer size, requiring an employer to have 5 or more employees under the State Labor Relations Act. That could be challenged by a workforce with 3 employees where the employees wanted to collectively bargain. It would then be up to the court to decide if the 5 or more employee restriction is a reasonable restriction on the right to collectively bargain, or if that was contrary to the intent of the constitutional amendment.
So, Damien, I would imagine that since we have a federal law, it's not in the Constitution, that federal laws sets as 5, and is that correct? The minimum number of employees, the National Act?
No, so it's the State Labor Relations Act is probably we have, I think, 7 labor relations acts currently in Vermont, and those would be the ones that would be under review in terms of our constitutional amendment. Our constitutional amendment would have no effect on the National Labor Relations Act. So federal law preempts state laws, including their constitutions.
Sorry, I know that, I knew that, and I was not expressing myself very well. I'm just wondering whether, I was thinking aloud really and wondering whether there was anything in the federal landscape that would help us predict what could happen in Vermont. And I think there isn't, because there is nothing in the Constitution that grants the right to organize at a federal level. It was an act of Congress.
Exactly.
Yeah, okay.
Yep.
I feel that, I mean, this is one sort of reflection, I guess, on the conversation, that if there is no legislation in place, and the amendment passes in 2026 at the polls, then it's sort of wide open. And if there is legislation in place that passes, if the constitutional amendment then passes, there at least is a framework there that the court could say, okay, you're doing this. Somebody could certainly challenge if there's a provision and say, oh, okay, you can't have 5, it has to be, 2.
Yeah.
But having a structure in place would be, as a default, I would think, a starting point that the courts might say, okay, yeah, you've got something.
Yes, I did also want to just point out that the proposed amendment only provides the right to collectively bargain. It does not provide a right to strike or guarantee a right to strike. So at least by its terms, it doesn't expressly guarantee that right. I can't predict with total certainty that a court would agree with me, but my reading of that is that the right to strike is something that can be granted, but that there are other dispute resolution mechanisms that are found in many collective bargaining laws. For example, our state employees and our public safety employees don't have a right to strike. Currently, we have essentially binding arbitration at the, I say we, I don't have the right to collectively bargain because I work for the legislature. State employees and public safety employees have binding arbitration at the end of their dispute resolution process, where a third party essentially determines the contract. That's just to the extent that there are concerns that Prop 3 would bring in a right to strike across the board. My opinion is that's unlikely because it doesn't expressly guarantee that right. It does expressly provide the right to collectively bargain. And I think that does open the door if you don't pass legislation that the court could have a decision similar to what happened in New Jersey, granting that right. And then it would be up to you to establish parameters for that if you don't enact legislation in the meantime. These are a lot of ifs. There's a question of whether Prop 3 moves forward next session. There's a question of whether any of this legislation moves forward. So, but right now for the study committee, the big question is what sort of framework would you propose if you had to propose a framework for the legislature to consider?
Can I just ask one more technical question, Damien? The second biennium requires only a majority, if I'm right. It's 2/3 in the first biennium.
Yes, I believe that's correct. If you give me just a moment, I'll confirm that, but I believe that's correct.
Okay.
All right, well, while you're looking that up, Damien, why don't we go ahead and have Sophie pull up the side by side, right? So let's just sort of quickly walk through the whole list. And then while we're doing that, we can all be thinking about where can we start here? And we'll, take suggestions there.
So as came up this morning, the State Labor Relations Act was the one that was amended in the recent legislative session to remove the exclusion for domestic workers. And that statute explicitly currently excludes agricultural workers. And so just again, that statute, I think Damien had said in one of the earlier meetings that this committee had, the State Labor Relations Act that only covers private employers who are not engaged in interstate commerce, so it doesn't have a broad scope to it, and it really hasn't been used much. So one of the reasons for including Vermont State Employees Labor Relations Act on this chart was a statute that is more actively used because the State Labor Relations Act really hasn't been used very much over the past several decades, almost 55 or whatever it is, that it's been in place. So just I share that because there's a whole lot of history and case law and stuff interpreting the State Labor Relations Act. So obviously no definition of agriculture in either SELRA or the State Labor Relations Act. Maine's Agricultural Employees Labor Relations Act would have included a very extensive description of what's covered. And again, just as a reminder, that act passed in Maine through the legislature, but then was vetoed by the governor in January of 2022. So it's not in effect. Again, because the cannabis issue had come up previously, I just included under that first column for the State Labor Relations Act that Vermont law currently, I think this is under a taxing, it's under a tax statute, does not consider cannabis growing as farming. So I just include that in there because we did hear testimony from Massachusetts that it was the cannabis growers that were the ones that were actively organizing in Massachusetts. And then, as noted, the minimum size of employer that's covered under the State Labor Relations Act is 5 or more. In Maine, it's more than 5, so it'd be 6 and up. None of the statutes currently differentiate between covered employers. That was one of the questions the committee was asked to consider. Definition of covered employees, so I can put that in there. And again, that's, to the question that was raised earlier, in terms of, how you define an employee, that's going to help determine who's eligible to be in a bargaining unit or not. And that often is looking at, again, what the connection the employee has to the employer. Minimum number of employees in the unit, and again, there isn't a the employer has to have at least 5 to be covered, but there isn't a specific number of employees in the unit. But generally, as reflected in decisions related to SELRA and then under the Maine statute, proposed statute, is usually labor relations boards are looking at, is there a community of interest between the people that someone's seeking to organize, and would there result in over fragmentation? I don't know for farm, but for farm, if you had a large farm, for example, you might theoretically have separate units on one farm. I'm just thinking about the testimony this morning, if someone has both, livestock, dairy farming, and they also have a crop operation. I mean, theoretically, you could have those be 2 separate bargaining units on a farm. And again, it would look at the community of interest. Is there enough common interest between those 2 different groups? I mean, my sense is Vermont, farms are going to be much smaller scale than they are in some other states, but that's typically what's looked at. Over fragmentation would be, you don't want hundreds of tiny little units, but again, our farms are pretty small. None of the statutes that I've listed here address seasonal, migratory, or temporary workers. Again, under SELRA, State Employees Labor Relations Act, they do look at, are you a permanent, you could be a permanent part-time employee, or a limited status basis, but it's not just somebody that comes and works for a month and then goes away. You consider to have that connection to the workplace that would support them being in a covered unit. There are different approaches for how you select and certify representatives for a unit. So under the State Labor Relations Act, you can have voluntary recognition by an employer. So again, if employees are interested in unionizing and the employer is comfortable with that, again, we kind of had testimony this morning that might be the case for some farmers. The employer can voluntarily recognize them under the State Labor Relations Act. That's not true under the State Employees Labor Relations Act. There can't be voluntary recognition. And then the other 2 ways are majority sign-up or card check, which was recently passed by the legislature, again in Act 117, or secret election, which is the traditional way that that's done. And again, those are the same options that would have been available under the Maine Act. We did hear testimony before around procedures for decertifying units or decertifying a labor organization that's representing workers. So I included that on the chart as well. That wasn't something that was specifically requested by Act 117. And typically it's kind of the same process in reverse of when you're actually seeking to have a representative. The difference is that it would be by secret election. You don't have majority sign up, card check, whatever is not available if you're looking to decertify a union. And then the rights of employees, I paraphrased here, but generally sometimes there's a bit more detail, but the principal ones are to self-organize, to form or join a labor organization, to bargain collectively, and then also the right not to join if you choose not to. Mandatory subjects for bargaining under the State Labour Relations Act, rates of pay, rules, hours of employment, conditions of work, and a process for dispute resolution. There's more detail under the State Employees Labour Relations Act on what's covered. Wages, hours, and working conditions in the main act is sort of the pretty standard language that's used. Again, looking at procedures for resolving bargaining impasses, but because I think the State Labour Relations Act really hasn't been used that much since the 60s, it doesn't contain language about how you resolve them. So this is where it might be helpful to look at some of the other statutes, labour relations statutes that we have in Vermont. SELRA, for example, it's a multi-step process. The goal is always to resolve disputes, you know, at the sort of earliest point possible. So you have mediation fails, then you go to fact finding or non-binding arbitration, and then as a last resort, you have what's called last resort, those decided either by the Labour Relations Board or by an arbitrator, and the decision is final. And, you know, in Maine, it's slightly different. They have mediation followed by final and binding arbitration. They don't have that middle step that we have in Vermont under SELRA. Typically, and I didn't include that, but under the Maine statute, it talks about costs and expenses being shared equally. And I think there was testimony about that previously in front of the committee. That's traditionally how it happens in Vermont as well, is that when you go to arbitration or fact finding, the parties typically share the costs, they just split them evenly. So strikes, the State Labour Relations Act it doesn't talk about strikes, it just mentions, you know, it sort of assumes that you can have the right to strike without actually having any provisions that specifically talk about the right to strike. So it talks about unfair labour practices by a labour organisation would include secondary boycotts and picketing other businesses. 60 days notice or expiration of the contract, whichever is later is required before a strike or a lockout. And that goes to the question that Senator Brock asked before. That's pretty typical in some of the other labour relations statutes that I looked at elsewhere in the country, where there are specific agricultural ones, is that you have to have significant period of notice, I think precisely to address the concerns around, you know, crops, harvesting, care of livestock. You can't just announce it and then strike. You have to have a long period in order to make sure there's a way to minimize that and give the parties an opportunity to really think about whether that's the path they want to go down. And then under the State Employees Labour Relations Act, there is no right to strike or recognise a picket line while you're performing your official duties. And again, the main one did not specifically prohibit strikes and lockouts, but again, had a significant notice period included in their act. Unfair labour practices, I didn't list everything out, I just kind of got the main ones. And these are the ones by employer. There are also unfair labour practices by employees are typically listed. But again, I didn't list all those out. And then the oversight entity for the State Labour Relations Act, it's the Vermont Labour Relations Board, as it is for the State Employees Labour Relations Act. And then in Maine, they would have had their main Labour Relations Board would have overseen their act had it gone into effect. And as I mentioned, there are a couple of other states where they've created a separate board, but those are states with, you know, billion-dollar sized agricultural economies. And then one of the questions that the committee was asked to consider was state resources. There aren't any specifically listed in any of those statutes, but we did hear testimony, the committee had testimony that in New York, for example, where they introduced overtime pay, phasing in overtime pay for agricultural workers, that farmers are being compensated to cover the cost of that, at least at the present time. So other states have provided additional supports to farming communities and health and compliance. So there are costs that other states have incurred.
Right, that's the end of the list.
That's the end of the list, yes.
Well, leave it up there.
Oh, you want to-
if you wouldn't mind. I think it would be helpful to
Okay.
have it up there. So let's just open it up. Does anybody want to pick one of these item from the left-hand column and share a suggestion or ask more questions about it. I think it's probably going to be the case that there are items here where we feel either as a group or individually, I would like to know a little bit more, we hear more information before I could, weigh in. Hopefully that won't be the case with all of them. But it may be the case with some.
Earlier, I mentioned the childcare and home care provider model, which I'm still intrigued by. The main difference seems to be that the state has a role in that. Thus, is one of the negotiating partners. I don't see the state having the same role here, but I see the need for somebody in that role. I don't know who that is, and that would be to allow smaller numbers of workers to organize without having it, that negotiating pressure devolve onto a farm with 2 or 3 employees.
I think in the context that we have, the childcare and the home health care, I'm not sure that it's limited to small employers. I think that you have.
No, I don't think it's limited to it, just does go down.
So when we talked about this last time, Damien, jump in here, or Sophie, jump in. I think we recognized that one of the differences there was that, yes, there's state money that's, and that is the reason, or at least a significant reason for why there is, why this, the state is negotiating with those workers, which is not the case here. Currently, so as you could argue, there's some state money that goes to farmers, but it's not, it's part of an employment agreement.
Right. I think Damien also had mentioned that there are actually nobody has organized under the child care.
Right. I think that if we can, flag that as something that I'm a little worried about, just the time that we have left to hear too much more testimony on things that I don't know will be helpful in getting us to answer these questions. But if we feel like, this is something that we want to propose as part of a structure, then we can. I'm not sure, Robin, whether you're just saying, we would like to learn more about this, or just pointing it out, or.
I would like to learn more about it.
Okay.
Seems to have addressed the small number of workers question, which is something that was raised. Both Farm Bureau recommended that 2 workers be a minimum number.
Yep.
And I think agreement, Microjustice agreed on also allowing small numbers to organize.
Why don't we have, ask then if for the next meeting, Sophie, if you or Damien can give us a little more. We had just a little bit of background, I think, maybe in our first meeting on that, but maybe, good. All right.
Thank you, Mr. Chair. So I'll just kind of put the cards on the table as far as the way I see it. I would vote to recommend, and I realize this has a lot of constitutional implications and everything else, because as we discussed, it's not clear yet whether the second biennium will result in an affirmative vote on the constitutional amendment or not, or maybe the popular vote would or would not. But absent that, I would vote to recommend maintaining the exclusion for ag laborers to unionize. If that is not going to happen, I definitely would vote not to support any striking. I think Brian Carpenter made some good points, and they were made, I think, by Jackie Folsom from the Vermont Farm Bureau as well. You're talking about animal health there, and food security, basically. Robin just brought up another piece that I think is resonating with me. Rather than make it appear that we're picking on large dairy farms, I would support a number of 2 or more employees in order to put this thing into effect. I still think, and I'm looking through the side by side, definitionally, we've got a lot of work, I think, still left to do. What's an employee? What's a farm? You know, we always seem to get into this thing in agriculture where, and we had big arguments last year about whether cannabis should be included in farming or not. Some people feel strongly on one side, some feel strongly on the other. And again, I think there should probably be a separate labor relations board that at least has some representation from the agricultural community in order to vet whatever might be happening. So that's where I am. And
Thank you.
it's sort of like a road that's got a lot of different exit ramps. And they're just recommendations from what I mean, I think, and Senator Ram Hinsdale and I talked at lunch, this will undoubtedly be brought up again in House Ag and Senate Ag next year, and maybe in economic development on both sides to come up with whatever it is.
Maybe in House General too. Okay, so good, thank you. So I think you mentioned 3 things: strikes, minimum number of employees, and board, what oversight board, what entity would have oversight. So anybody have any reaction on any of those 3? Let's talk about those for the moment.
Well, so I heard something underneath all of that, which was not moving forward at recommending against allowing the right to collectively bargain or form a union. I'm glad that you're saying if it's the majority that wants to continue to figure out the other parameters, then you had other suggestions, but I guess we probably still at some point need to, on the early side, figure out if the majority opinion is to recommend to the legislature that this group of workers be allowed to organize. Unless you were trying to avoid that question.
It was not, yeah, I was not trying to avoid the question. I guess my own perspective on it is that we have had, I guess we've had 15 hours of testimony, essentially. We've had very little discussion at all.
Yeah.
Committee discussion. And I was sort of thinking that some of that would be surfaced in the conversations. So no, not trying to avoid it.
Okay.
Just not quite sure if we're even like individually ready yet to say it, because there are a couple of different directions we can go. One is to say, here's a framework. We voted X to X to support it, and then whether or not we actually recommend it, as opposed to this is what we agreed to put in here. That's a separate question, which makes it confusing.
Does bringing them up to employee status necessarily give them the right to collectively bargain? Or could you say, you are an employee, we are going to give you the state minimum wage, you will be guaranteed overtime pay, and can you then bypass the component of unionization altogether? I think unionizing, I will lay my deck as well. I am very much in favor of that, but I also think that we can address the areas in which we've heard farm workers are being disproportionately left out when it comes to rights. And as much as I want to support farms, it shouldn't be on the backs of those folks who are supporting the industry. And I think that we should look at minimum wage and overtime as being some of the most critical and pressing components of what it is that is lacking fundamentally in that industry.
One of the things that I would just raise is we're talking about agriculture now because that's the thing that's on the table when people come forward. I still don't know. There are other groups within employee base in Vermont who also have exclusions of certain kinds of things? Are there any who, for example, don't get overtime because of the nature of the job in statute? What will, again, most critically, what are the implications of Prop 3 to all of this? What are the implications of not being able to strike? I know we certainly have statutes all over the country where police officers, firefighters, and others, for example, may be restricted. Do we have any potential restrictions based on what we do and kind of framework that we're talking about here for ag workers or anybody else? And we haven't talked about those things.
Yeah, so I think that the only group that's left out of the state act now is ag workers after we made the change last
Yeah, right. We
year.
dealt with domestic workers last year.
Yeah. But as far as employment laws, so minimum exclusion from minimum wage, I think we did hear some testimony from Damien earlier in the fall about that. Damien, you can refresh our memories. Whether other groups of employees or other industries have an exclusion. And I remember asking about tip employees. That's why I'm saying I think we did hear something about it. And Damien, I think you pointed out that, yeah, it's different for tipped employees, but they still ultimately do have to get the minimum wage, the state minimum wage in Vermont.
Yeah, that's right. They're required to be paid at least a base wage. That's half of the standard minimum wage. And then if their tips don't bring them up to the standard minimum wage, then their employer has to cover the difference to make sure that they at least earn the standard minimum wage. And it varies widely across the state, as I'm sure you can imagine. Tipped employees in some of our resort towns can make really good income, and tipped employees in some other areas of the state may not see such good income, and so their employer might need to boost their wages periodically if it's a slow day at the restaurant.
And are there any other industries other than agricultural workers who aren't eligible, who are exempt from minimum wage or overtime?
Sorry. There is a list of exemptions. It is, let me just pull it up here. So excluded from the definition of employee for purposes of the minimum wage is agriculture, domestic service, employees of the United States. So we don't mess with what the federal government pays its employees. Individuals employed in the activities of a public-supported nonprofit organization, except laundry employees, nurses, aides, or practical nurses. That one we think dates back to when there were state institutions or public state-supported institutions that employed some of the inmates at those institutions. Individuals who are salaried employees, individuals who make home deliveries of newspapers, taxi cab drivers, outside salespersons, so those are door-to-door salespeople, and then students working during any part of the school year or regular vacation periods.
Damien, just those are the ones that are excluded from Vermont's minimum wage.
Yeah, that's Vermont's minimum wage and overtime. The federal list is longer and more complicated. But to the extent that the state minimum wage provides a minimum wage for someone who's excluded from the federal minimum wage, then that the state minimum wage would prevail. The other thing that's worth noting in Vermont is that our overtime laws also provide certain exemptions there. Individuals who work at a retail or service establishment are not entitled to overtime pay. Individuals who work at an amusement or recreational establishment that does not operate for more than 7 months in a calendar year, or that earns 2/3 of its income in 6 months of the year are exempt from overtime. Individuals who work at a hotel, motel, or restaurant are exempt from overtime. Employees of hospitals and other health centers are exempt from overtime. Well, they're really subject to a different overtime requirement that's based on either the workday or a biweekly 80-hour work period. They're exempt from the standard overtime requirement. Um, and individuals who basically truckers who are transporting goods through the state, because they're subject to requirements under federal law. Employees of municipalities are exempt from overtime. And then state employees who are covered by the Federal Fair Labor Standards Act are exempt from overtime. So some state employees are covered by that, others are not. And then finally, this past year, you also excluded legislative employees from the overtime provisions.
So, Representative Supranant, a moment ago, you suggested, I think, and I want to continue about that, the committee consider in one of its other recommendations. So in addition to the framework here, we can make other recommendations about employment laws. So you'd like the committee to consider a recommendation on the exemption, changing the existing exemptions
Yes,
for minimum wage.
for minimum wage
And overtime.
and overtime.
Right, so thoughts on that? Senator
I'd
Renner?
like to build on that and have a farm with dignity bill that talks about all those things, elevates the wages, deals with the working conditions and the overtime. And the way I reach that conclusion is looking at the other states that do have collective bargaining, it hasn't been used a lot. I'm not surprised. I mean, farm workers are flat out at the end of their 6.5 days of working. Organizing a union is the last thing on their hierarchy of needs. I think if we cut to the chase, the thing the legislature, I recommend doing would be to just go straight to that issue of wages, working conditions. And if some farmers can do the milk with dignity, then all of them can, do it, as far as I'm concerned, coming at this from just, let's address the problem, let's address it directly, and let's not put the burden on these exhausted employees and these exhausted farmers. To somehow find a way to bargain and come to a resolution, and it just makes me tired to think about it.
We did hear from the Massachusetts Labor Board that they don't think they've had any unions formed until the cannabis legislation. I don't know that we heard that specifically from about other states. I mean, we haven't looked into it. I would also say though, except with New York, where we heard, yes, they have had some bargaining units formed. But anyway, the larger point is it's a lot of work and yeah, a lot of these.
But I mean, I love collective bargaining as an ideal. I'd love to see that in every workplace, but for resolving these issues, in all the testimony I heard, that's what I recommend.
Can I ask? So when we, the testimony, a mention of the farm program, which had inspections, spot visits from the producers, the dairy producers. Based on summary of key points provided, number 7 talks about 8,331 agricultural employees in the state, if you add those numbers together. And then number 8 mentions 852 migrant workers. Doesn't say how many, but it doesn't say how many are in dairy. Of the 8,000, how many are in dairy and how many are in other agricultural pursuits? And I'm just wondering about the enforcement or inspection or you know, the teeth behind something. I like the idea, just.
Be self-reporting, it could be employees having a. Sort of contacting the state, I'm open to
Just something to refer
something
to.
creative.
Yeah.
There. Just trying.
I've also been thinking a lot about the fact that I don't know how much use the ability to unionize and collectively bargain, I guess. Like, I mean, like other ideas.
Representative Bartlett.
I have a lot of concerns about overtime. I wanted to know more of what New York was looking at for their financial resources they're offering farmers. And from my research is showing that there is a tax credit if a laborer works from 56 hours, but no more than 60 hours. So then a farmer could get a credit for essentially 4 hours. But we had Richard in here earlier saying that on average, he has workers working 80 hours a week. I know that our farmers are not going to be able to keep up with overtime pay. They've, in Franklin County, I talk to our farmers, they just cannot pay overtime pay. So as an employer, as someone who's in HR, what I would do, my recommendation would be, okay, if you can't afford overtime pay, then at 40 hours, you have to send your employees home. And then you have an employee who wants to be working, and now they either have to face finding another job or they're out that money. So I think there could definitely be some negative consequences in enforcing overtime for ag.
We had some, I feel like we had some testimony that talked about that and what it would mean. Maybe it was the New York State testimony.
I think it was, yeah.
Employers having to make that decision. This morning, right, we heard Richard say that, well, he could jigger his pay scale, I guess, so that to lower the base pay, and so that the time and a half, the math would ultimately work out, but that may not be the case for everybody.
Yeah. And additionally, I think, as Damian had mentioned, there are other exemptions from overtime pay. And I think that this one should remain in.
I just asked Sophie then about one more thing, or Damian, the strikes were brought up earlier. So we've heard the testimony from a number of people explaining, I think it all makes perfect sense, of the risks associated with allowing the potential for farm workers to strike. But I'm wondering also if either of you could talk about what it would mean to have a provision that says strikes are not allowed. That would be handcuffing the employees, the unionized employees, if they didn't have that right. I guess I could say that much, but what would the implications actually be? So we do have state employees, and this, you've shown it to us here, Sophie, don't have that right. It takes away bargaining power, I guess, in a simplified way of explaining it.
I guess my sense is that it's there are pluses and minuses, because if you have the right to strike, the employer has the right to lock you out, you can lose your job. So it's, the goal of the labor relations statutes is really to push the parties to get things resolved. And so there are just different mechanisms for doing that. But I would say under the State Employees Labor Relation Act, you have the mediation, you have non-binding arbitration, sort of fact finding, and then this last best offer, which either you have as a binding arbitration or you go to the Labor Relations Board, where it kind of forces each party to move to the middle because you want your last best offer to be adopted. But people aren't locked out, they're not, they're continuing to get paid. So they're just different mechanisms. But the goal is always to resolve the dispute, as sort of expeditiously in the least harmful way possible.
Yeah.
So, yeah, I mean, strikes, you can be locked out and, you can ultimately lose your job and stuff. So depending on the nature of the strike. So it's,
So I want to just follow up on that, because I'm not sure that we've talked about it, but there's something called locking employees out. And you just tie those two things together, striking and locking employees out. One is the right that the employee has and one is the right the employer has. Are they always hand in hand?
I don't know about always, that's just how I'm in my relatively limited experience, but usually, you have a clause that's like no strikes, no lockouts. It's kind of a quick pro quo, you can't strike, but we're not going to lock you out. It's kind of a balance done that way. In the State Labor Relations Act, it doesn't sort of talk about that. The only one for me is thinking about like the Teachers Act, where, that's teachers can strike, but then there can be a contract imposed by the school board. So again, just different mechanisms with the goal of getting, ultimately everyone back to work and, the enterprise moving forward.
So in the school context, the school boards, employers can't lock out teachers, but they can impose a contract. That's a.
And I'm assuming that's why the charge in the act was strikes, contract imposition, sort of tying those two. That was sort of the same request for the committee to look at. And Damien may have more knowledge on that than I do. I'm not as familiar with the Teachers Labor Relations Act.
Yeah, that's a good summary of it there. It's been referred to as the two hammers that each side has at the end. So the school board, if they aren't willing to agree, can impose the contract and say this is what it is. And then the teachers can always go out on strike. What we've seen happen with that is oftentimes one or both parties will use that authority, and then the public backlash is so bad that they usually go back to the table and work out a deal. The alternative processes where you provide for some sort of alternative dispute resolution, like a binding arbitration, it avoids a lot of that problem, and it does drive the parties to the middle. One of the biggest problems with that in this context is that unless the state provides that as a service to farmers and farm workers, that's very expensive to buy. That's a very expensive service to get from a private arbitrator.
Thank you, Mr. Chair. So to me, there would be little difference if I were a dairy farmer between having employees strike and locking them out. If the farmer doesn't have the ability to draw on this amazingly large pool of other workers. So to me, he or she's in the same position regardless. If the milk is ready to be brought to market and for whatever reason, whether it's a strike or locking them out, he or she is in the same position. It doesn't, so I don't see it as a quid pro quo kind of.
Thank you. Yeah. Anybody else have any thoughts on this one issue? It's not that just because I think we need to start somewhere. And maybe this feels like something that's concrete enough that we can either come to some sort of agreement or feel like, no, okay, we don't have an agreement or we want to, hear more information. And then we can circle back to some of the other things that have been mentioned too. But so any other thoughts on should there be the right to strike? And if we were to set up a framework?
I just think that perhaps there wouldn't be a need to strike if we were addressing people's basic needs and rights in the workplace, and that could all be avoided if we shifted the ways in which we looked at labor law, and then there wouldn't be that concern that that would take place. People aren't striking because they're thrilled with the conditions. They just want that to be remembered.
Okay. So if we were to change some of our employment laws that made.
It would preclude the need to even consider whether or not people should have the right to strike, because we would be addressing what the needs are in the workplace.
And are you also saying it would preclude the need to have the right to organize?
Yeah, I do stand by that. I mean, I love unions, but I think that if you're addressing what the actual root of the issues are, then I do think that the right to unionize becomes less necessary. And especially when you're looking at a field like agriculture, where there are all these specific and unique needs on farms, and having to put it into the time frame of farmers themselves to come up with all of that. If you just give them a blanket safety net of what it is to have rights as an employee, then that feels like one of the most, it's a generous and a very bare minimum of what we can do for these workers, instead of putting it in the hands of individual farms and farm workers to figure out what they need to do to address their own basic living conditions.
Okay, so just to ask, who would be determining what was the floor on that?
Us. We're
So we
determining,
will put it in statute that X, Y, and Z has to be in place?
would X, Y, and Z be meeting a state minimum wage and overtime requirements?
A specific hourly wage, et cetera?
Yes,
That's.
that is exactly what I'm
we would
saying.
do, yeah.
Yeah, that is 100% it.
We just wouldn't exempt that from.
What's that?
Things such as lodging and the other things that are associated with most farm worker situations now.
Those have no bearing on their wages.
Well, the wage theoretically right now has to be the minimum wage. If we applied that kind of a test, and then would they have to buy the housing out of that?
I don't think all workers are getting minimum wage, and they're certainly not.
But I'm saying, if you put that into law right now
Mhm.
and you enforce it, how would you deal with the lodging situation?
So
And who would decide what the value of the lodging is?
H2A workers get a minimum of $17.80, and there's no deduction for lodging. And I think the condition of the lodging is a question. I mean, we've had this discussion on the housing side, because if they have trouble with their location vis-a-vis the farm or accessing the private market for housing, it's not like they can take their wage and go get other housing. They're pretty bound to what's available, which, we wouldn't be able to set a standard deduction for, because it might not be worth what we would set as a price. So I would think we would be discussing at not exempting them from the minimum wage without any specific deductions, I think. But, that would complicate our minimum wage.
That just raises innumerable other questions, like what's the enforcement mechanism? Who inspects this? Who determines whether it is or is not adequate?
Housing, that's another bill that we have to work on.
Well, I mean, again, you have an endless set of tests and criteria and measurements and the labor and so on associated with doing that.
Well, everyone we talked to today said that their wages are well above the minimum wage. I mean, when we've had minimum wage discussions in committee, it's been who isn't making the minimum wage? And they're usually not the people who come and testify to us, So if we trust the word of these, likely good actors that they, people deserve to be paid, you know, well above our state minimum wage, then I think it is worthy, because in terms of the impact of our decisions and our recommendations to the legislature, I think minimum wage, not exempting them from minimum wage is probably the one that is foundational in the discussion, not necessarily the right to strike, since we've seen that that's a right to bargain or strike that's available elsewhere. It's not often used. And I think if we were to talk about the right to strike, going back to your actual question, you know, I know a lot of those 14 states have different provisions that might create some exemptions for, you know, when it's not safe to strike, just like when law enforcement can't strike. But again, I do agree with Representative Supernaut that it feels like we should aim to answer the biggest question first. And I think our committee will have a minimum wage related bill. People have asked us to look at that for prison labor, people who are incarcerated, who are employed, and just look at the minimum wage. So it could come in any number of places, that discussion, instead of like a farm bill.
So, I think I'm hearing from more than one or two people that they're feeling that the emphasis ought not to be on the framework for the collective bargaining agreement, but rather on wages and overtime and maybe other things, but those two things at least. And that whatever we come up with for a framework, because we'll just step back and say, that's the first thing on the list that we're supposed to do, is come up with a framework. But whatever we come up with, it may not be something that we collectively are going to say we recommend it. But if there were one, here it is, because you told us to put one together.
In a way, what I hear Representative Supernaut saying is that we might somehow articulate that after a lot of testimony, we've learned that while the unionization provision might be nice to have, it hasn't materially changed the lives of people in these other states necessarily. We haven't seen it used in a way that is adding to their quality of life or employment. Not instead, but maybe there's more emphasis on the things that actually materially impact their quality of life. That's kind of what I think. That it's like we've looked around and seen maybe the unionization is a little bit more symbolic. Maybe it would be nice to remove that exemption because it's painful for people to think about from a historical perspective. But it's probably not going to make anyone unionize overnight. I mean, Massachusetts is a pretty big state with lots of farms to have never had this come up in a dairy or, you know, regular commodity sense.
So if I can summarize to the best of my ability, what's being suggested is that we recommend not giving collective bargaining rights, no strikes, and that we somehow work to get wages to a level where everybody can sort of be happy. The only thing I mentioned is if I were a farmer and I don't pay minimum wage yet, and now I'm going to be told by the state of Vermont, you have to, there's a gap. And we have to Representative Bartley's point earlier, I think maybe tangentially, there has to be some consideration given to that farmer, how that farmer is going to get to that point without just taking it out of his pocket. I don't know how else to put it.
I agree. And I think that there's a variety of ways in which we already subsidize agriculture that could be shifted from some of the ones that go towards, say, water quality, and instead shift it more towards an equity-based income system that would help you account for some of those additional wage increases. But you know how much we put into agriculture when it comes to the environment. And as much as I love the environment, I'm all for it. There are other ways in which we could start investing some of those dollars that would have a real impact on the conditions of employees and help the farmer as well, because I think that's a critical consideration. You can't forget the farmer in it themselves.
Okay.
Right. Senator Renner.
As some of you are also ag committee members, we hear all the time about things like beef on dairy and other conversions that farmers are being encouraged to do. If the price of milk is still too low, then maybe this oversupply needs to be cut back, and this is one of the ways that will incentivize it directly or indirectly. Fewer dairy cows, crops, or beef, whatever it takes. Vermont farmers for years, for centuries have been adaptive. There will be a little window, maybe a big window, before these new constraints are put into effect. And we give people that chance to make some hard decisions, maybe as to where they're going next and how they're going to meet these regulations. Are they gonna beef up the housing, or are they gonna stop housing workers? If they're gonna stop housing workers, they're gonna have fewer workers. They're gonna have to change maybe their crop mix or their business mix on that farm. But I'm all for keeping landscape working. I'm just saying, maybe this drives the rethinking that's needed to happen for a long time on Vermont farms of where we go next.
All right, other thoughts? So,
Well, the thought that I always have whenever we say that we're going to look at these other methods, it's just who's going to pay for them and what are they going to cost? Now, I know that one of our speakers, I think today, indicated they had some ideas and other materials that they gathered from a variety of sources that would be delivered to us at our next meeting. To the extent that we could get any of that earlier writing to be able to digest it better, it would help us make better decisions. But right now, I don't see where the money's coming from.
so which was that the,
What was her name?
Maddie Kempner? That you mean?
Jane?
Jane Cliff.
maybe Jane?
Yeah.
Yeah, okay.
Okay.
So that Jane Clifford's testimony was about the organization that she was referring to. That's one of the links that they do have by state, all the different laws, and then they have a lot of documents on their resources, templates for HR policies and things like that.
He was talking about just methodology by which the kind of conversion that's being discussed here could be done. The subsidization of farms, for example, and the income sources to be able to do that. That kind of information or at least thought process would be very helpful to follow the kinds of things you're talking about and to see if they are in fact practical, as opposed to the heavy hand of the law.
I agree. I love practicality.
Senator Renner, did you?
I was gonna go back to this question of how we regulate. I mean, the Milk with Dignity folks clearly have some way of regulating all of the benefits of their farmers that are plugged into that program. The H2A workers have their own way of regulating. So I think looking at the existing ways that farms are regulated when following these different conditions that we want to change, I think we can come up with something to propose.
So,
Any information about Milk with Dignity, for example, what percentage of farmers are participating in that program? Is it meaningful?
did you get
We did.
the number?
He did share that information, I think, but it's only the ones that are like working with the St. Albans
Right.
co-op.
But I mean, just of the overall category of dairy farmers we have in Vermont, how many are?
I think he said something like 256 were signed up, but like 10 of them aren't actively in the program because then maybe they're not doing dairy right now. So maybe there were something like 246 that were active. But it is only Ben and Jerry's was kind of my takeaway from that, that it was only one.
It's the only buyer. Yeah.
Right.
But you can't go to a grocery store and buy milk that says,
Produced by.
there's no way to do that. It's all commingled.
Yes, and I think it's all going into ice cream or into Ben and Jerry's products anyway. Yeah.
I'm looking at the National Dairy Farmers American Farmer Program. Not seeing, well, I haven't had time to go and see if there is an enforcement or a oath or a, how are the standards promulgated, enforced?
Just looking at it was 200 Milk with Justice, Milk with Dignity, 256 qualifying workers, and 42 actively participating farms in Vermont and New York. So it's not just in
42.
42, and that's both upstate New York and.
The farms that we had in the north.
And New York.
And
It's a pilot program, basically.
Good. There's a little lull here. But I realized we've been going since 1 o'clock and we got up to gradual stretch. Let me take 5 minutes, just get everything stretch, use the bathroom, and then we'll come back and get wrapped up.
Okay.
Good.